Former Police Sergeant Ben Cooke, 34 years of age, wasn't, I presume, believed by anyone at all when he said that his acts of theft, burglary, attempted burglary, unauthorised access to police computer material and corrupt exercise of police powers, offences which he committed between January and February 2024, were due to the blackmail and the duress from unknown parties that he had suffered. On the 11th of July 2024, Cooke was given 6 years and 4 months for his offences, but will only have to serve half of that time in prison. The rest he will serve out on licence. Before crossing over into criminality, Cooke had been in the police for all of a decade and had an unblemished record. His first step into offending came just after Christmas of 2023 when
you and other officers attended a sudden death at a property in Pencoed. £16,870 was seized from a safe in the property for safekeeping. It was being saved by the deceased for his funeral. It was counted, and that count was recorded on body-worn video. Outside the property, you spoke to Miss Price, who was the deceased's sister. She was not allowed to enter the property and was not aware that the cash had been seized. 2 days later, her nephews told her that the money was missing, and so she reported it to the police, who told her that they had seized the money. On the 4th of January 2024, while the officer who was tasked to return the money was away, you went to Miss Price's home to return the money to her. You counted it in front of her, and she signed to acknowledge receipt of the cash. She told you that she was going to put it in her safe. You asked to use her toilet, which was situated next to the front door, and then stole the key to the front door, which had been left in the lock. Later the same day, Miss Price realised that the key was missing, and she replaced it with her spare key.
And this was the one thing in all Cooke's outrageous scheming that he hadn't counted on, and it would, rather farcically I'd say, scupper his very outrageous scheming.
Your personal vehicle was seen in the same street later that evening. On the afternoon of the 8th of January, using a mobile phone that you had obtained for the purpose, you telephoned Miss Price pretending to be someone named Thomas from the coroner's office. You told Miss Price that she had to attend the Prince of Wales Hospital in Bridgend urgently, as there was an issue with her brother's post-mortem examination.
As objective observers, it's probably easy for us to step back and question what sort of discovery made in the course of a post-mortem examination could truly be described as urgent. It could hardly be a matter of life and death, for instance. But I have no doubts that it's much less easy to pick up on such questions when you're suffering both the shock and the sadness of losing a loved one.
She was on a bus on her way to Swansea at the time, but she made her way to the hospital in Bridgend. You telephoned her a second time to check that she was still on her way to the hospital. At the hospital, Miss Price discovered that no one named Thomas worked there, and that none of the staff had contacted her. In the meantime, having ensured by that means that Miss Price would be out of the way, you went to her address that afternoon, wearing black clothing and carrying a black Under Armour rucksack. You would not have been able to gain entry using the key that you had stolen, because the spare key was still in the back of the lock.
And shame on him. I do wonder though how Miss Price herself was subsequently able to access the property as she presumably did. Anyway.
When officers searched your home address on the 15th of February this year, they recovered a black Under Armour rucksack from your bedroom wardrobe and found Miss Price's missing front door key in the side pocket of that rucksack. On the 6th of February 2024, you carried out searches on police computer systems into an address in Maesteg and the family that lived there. You did so because you had seen intelligence that suggested that £60,000 in cash was present at that address. At about 11:45 hours the following day, the 7th of February 2024, you went to that address. One of the occupiers, Miss Watkins, was at home and was in the shower. She heard 2 knocks on the door and then heard the front door being opened. When she opened the bathroom door, she was shocked to see you standing there dressed in full police uniform. You told Miss Watkins that you had a warrant to search the house due to suspected drug dealing. You had some paperwork, but she was not permitted to see it.
Entering the property knowing that he had no entitlement to do so and entering with the intention to steal makes Cooke liable for a Section 91A burglary under the Theft Act 1968. Even if he hadn't actually stolen anything, he would still be liable for burglary. We know why Cooke wouldn't show Miss Watkins his non-existent search warrant for her property. His failure to show Miss Watkins proof of his right to search her home, though, I believe breaches one or more rules from PACE, the Police and Criminal Evidence Act. If so, this is an example of Cooke's corrupt exercise of police powers. So, of course, is Cooke's disclosure to Miss Watkins that he had a reasonable suspicion that drug dealing had been carried out at Miss Watkins' home. Cooke was alone and had, presumably, broken Miss Watkins' front door in order to enter her home. Police officers are entitled to break into a home where they suspect drug dealing to be taking place. You never get one police officer alone performing a drug raid though. But again, when it's happening to you and coming out of the blue and you're totally unprepared for one such event, you don't think to question that point. Of course you don't.
You confirmed with her that there was no one else in the house. When Miss Watkins asked if she could telephone her husband, you said no and took the phone from her.
Cooke's behaviour was rude, aggressive and vastly intimidating. He had no guilt and no shame.
You told her to remain sitting in the living room. You then went upstairs and located the family safe in the main bedroom. You brought the safe down and asked Miss Watkins for the key. She told you that she didn't know where it was. You asked her what was in the safe, and she told you that there were photographs of her grandson, some jewellery and collectible coins, and an unknown quantity of cash that belonged to her husband. There was estimated to have been about £16,000 in cash in the safe. You told Miss Watkins that you had to take the safe away to get your colleagues to open it. You told her that you could not give her a receipt as she did not know the contents of the safe.
Again, as outsiders who aren't suffering the shock and horror of a police officer's unexpected invasion, during which the officer makes all manner of outrageous accusations and demands of us, we can again easily step back and question why not knowing the contents of a safe that we legally own should mean that the police officer in question, who we naturally believe is only carrying out his police duties, however much we resent that, is unable to give us a receipt when he confiscates that same safe. To this day, the safe hasn't actually been recovered, and I can't say whether or not Miss Watkins and her husband have been offered any sort of compensation for that, as I just don't know.
You took a note of her mobile number and left at 12:31 hours. Miss Watkins immediately called her husband, Mr. Bailey. He came home, collected the key to the safe, and went to Bridgend Police Station to ask for his safe to be returned. At the police station, he was told that there was no record of police attendance at the address, and the matter was reported as a burglary. At about 18:34 hours that evening, you telephoned Miss Watkins and pretended to be PC Roberts from Gwent Police. Miss Watkins asked if you were the same officer from earlier that day. You asked if she wanted a crime reference number and if she had a pen and paper, and then you hung up.
This questioning from Miss Watkins suggests that she does have some intuition and perceptiveness and is able to question confusing situations when she's not suffering the unwelcome effects of shock, panic or fear. I would love to know why Cooke called her though. I imagine that it was to find out whether she had reported his earlier visit to the police so that he could try to work out how much time he had to make his next move, which turned out to be quite a surprise.
On the 9th of February this year, you telephoned the South Wales Police Anti-Corruption Unit and said that you wanted to hand yourself in as you had done something stupid. You claimed that you had been blackmailed and were in fear. When asked what you had done, you said that you had done a burglary, that you had been tasked to do it by persons that you didn't know but that you feared. You said that those persons had requested you to go to an address and remove something, which you did. You said that you had removed a safe with unknown contents and left it on wasteland near John's Lane. When you were interviewed on the 10th of February following your arrest, you claimed that you were being blackmailed because of your involvement with a female who you named. You said that a Bridgend-based organised crime group may have been responsible. You denied entering the property in my stake as a trespasser, claiming that you had been invited in as part of a setup and that you had been given instructions on where to leave the safe. You were interviewed about the first set of offences on the 29th of April this year. This time you said that you were being blackmailed because you had sent sexual pictures of yourself to another man. Others had discovered your occupation and identity and demanded money from you, which you did not pay.
A police officer with 10 years of experience who has, one presumes, heard the most stupid and unrealistic explanations from criminal suspects for their offences, not only comes up with the most laughable excuses for his own offending, but even then can't keep his story straight. In line with his warped logic, he appears to have deemed that not guilty pleas from him would be accepted by the court if they were balanced with a few guilty pleas from him.
Obviously, this offending is so serious that only an immediate custodial sentence is appropriate. Applying the sentencing guideline on reduction in sentence for a guilty plea, you are entitled to the full 1/3 credit for your guilty pleas at the earliest opportunity for the theft and the attempted burglary. You indicated not guilty pleas or no pleas for the burglary, the computer misuse offence and the police misconduct offence in the Magistrates' Court.
PTPH stands for Pre-Trial Plea Hearing.
At the PTPH on the 27th of March 2024, you pleaded not guilty to the 3 counts then on the indictment. You did not offer a guilty plea to any alternative offences. You asserted generally that you had been acting under duress. Stage 1 was fixed and later extended to the 30th of April. On the 2nd of May this year, the case was listed for plea, but you were not produced from custody that day, and so you were not able to change your pleas to guilty until the 9th of May. You are entitled to the credit that would be due to you if you had been able to change your pleas on the 2nd of May as you had intended. It has been submitted on your behalf that you are entitled to the full 1/3 credit for your guilty plea to count 4, as you pleaded guilty to that offence as soon as it was added to the indictment. However, you could have made an unequivocal indication of a guilty plea to this offence before that stage, or given an unequivocal indication that you accepted the facts and would plead guilty to an appropriate offence. You did not do so. Therefore, you are not entitled to full credit. You will be given at least 20% credit for that offence and for the burglary and computer misuse offences. Prior to the commission of these offences, you had a good character, a good career, and you were held in high regard by those who knew you. You have thrown it all away, and in doing so, you have tarnished the reputation of South Wales Police and of policing generally.
As if public trust in the police wasn't already badly damaged.
For the theft of the key, if you had been convicted after a trial, the sentence would have been one of 3 weeks' imprisonment. Less the 1/3 discount for your early guilty plea, the sentence is 2 weeks' imprisonment.
To me, that sentence is an insult to the victim. Now, the person that I want to see during these sentencing hearings isn't the judge delivering the sentence, but of course the person receiving the sentence. For me, that is far more meaningful.
For the attempted burglary, if you had been convicted after a trial, the sentence would have been 2 years, 6 months imprisonment concurrent. Less the 1/3 discount for your early guilty plea, the sentence is 1 year, 8 months imprisonment concurrent. For the burglary, if you had been convicted after a trial and to reflect your overall offending, the sentence would have been one of 8 years imprisonment concurrent. Less at least 20% discount for your guilty plea, the sentence is 6 years and 4 months imprisonment concurrent. For the computer misuse offence, if you had been convicted after a trial, the sentence would have been 2 years imprisonment concurrent. Less at least 20% discount for your guilty plea, the sentence is 1 year, 8 months imprisonment concurrent. For the offence of corrupt or improper exercise of the powers of a police officer, if you had been convicted after a trial, the sentence would have been 2 years imprisonment concurrent. Less at least 20% discount for your guilty plea, the sentence is 2 years, 4 months imprisonment concurrent. That means that your total sentence is one of 6 years and 4 months. You will serve up to half of your sentence in custody, and then you will be released on licence and supervision to serve the remainder of your sentence in the community. During that time, if you commit any further offence or fail to comply with the terms of your release, you can be recalled to custody to serve any remaining part of the sentence.
Cooke may be a candidate for accommodation in a segregated area of his prison for reasons, naturally, of his personal safety. With his sentence, though, was justice served? If you've enjoyed this video, I recommend you to watch this one next. I'll meet you there.